board of directors, key management personnel, etc. Dr. Narasimhan is a very knowledgeable company secretary, and I think we should have a better person than Dr. Narasimhan to speak on the subject. We all know that more and more sections are getting notified, and our life is going to be tougher in the month of April and May studying the Companies Act and the rules. I think some of the rules also have been notified. So anyways, before I invite Dr. Narasimhan to formally take a session, my request Mitesh to formally introduce Dr. Narasimhan.
Thank you, Vipul. Good afternoon, friends. It's my privilege to introduce our today's first speaker, Dr. V.R. Narasimhan. Dr. V.R. Narasimhan is a postgraduate in Commerce, MBA in Finance, PhD and member of Institute of Company Secretaries of India. He has about 35 years of work experience and about 30 years of experience in financial and capital markets in India. Presently, he is working with National Stock Exchange of India Limited as a Chief of Regulation. Before joining NSE, he has worked for 7 years in Kotak Group in various capacities as Chief Compliance Officer of Kotak Mutual Fund, CEO of Kotak Mahindra Pension Fund and Group Head of for Capital Market Compliances. During his stage with Kotak Group, he has set up Kotak Mahindra Pension Fund and played a key role in setting up of Kotak Bank anchored as Derivatives and Commodity Exchange Limited. He worked for 10 years with NSDL before joining Kotak Group from 1996 to 2006. He was a part of senior management and instrumental in listing companies with NSDL, setting up inspection department, was part of software development committees, was in charge of investor education, help desk, etc. He worked for SEBI in secondary market division between 1993 to 1996. And as a member of Institute of Company Secretaries of India, he has been a part of several academic initiatives of the Institute, including being on the Secretarial Standard Board and Capital Market Committee. With this brief introduction, now I request President Yatin Desai to present the memo to Dr. Narasimhan as a mark of affection. Now I request Dr. Narasimhan to begin his presentation.
Thank you, Mitesh, for the kind words for me. Mr. Vipul Choksi, Mr. Yatin Desai and the Chamber, I thank you for giving me an opportunity to speak about this topic. Actually, as far as this topic is concerned, I'm the first student for this, and maybe if you have not read the Act, you will also follow me. That's all. We are trying to reckon the facts as they are given in the Act as such. In the course of this presentation, I may be expressing certain opinions. Those opinions are my personal opinions as Narasimhan, and they do not represent opinions of National Stock Exchange. There's a disclaimer from my side, but let's be very clear on that. I think the essential crux of the new Companies Act, as I understand, is that they have tried to create a lot of personal responsibilities on the people who are running the company. If you look at various provisions that have come up, most of the time the Act willingly would like to push the responsibility on the person who's handling a particular job. Instead of giving it nebulous and then open, they are trying to push it on the head of specific persons. That's what we see as an underlying theme across various sections of the Act. So in the Board of Directors provisions also, you will find this particular flavor very clearly. We try to explore it as we move forward. As you all know, as Mr. Vipul said, 183 sections were notified just 2 days before. Out of the 470 sections, 280 sections are now in operation. Other sections which are not in operations have got the word tribunal in them. Since the word tribunal is there, that's not been operationalized because of the Supreme Court case against it. Otherwise, 280 sections are already there. And I'm told some rules have been notified today. So our life is going to be tough. We have to understand the rules, we have to understand the Act. Mischievously, the lawmakers said that we have reduced the number of sections in the Companies Act from whatever it is to 470, but in fact they have increased the scope of the Act by adding so many rules. So we have to handle at least 2 books, if not more, to be able to understand what Companies Act is going to be all about. That is, you read a section, it's not sufficient, you have to read the rule too. And unless you read these 2, probably you cannot understand the impact of particular provision in law. So that's going to be various immediate impact on us. I straight away go into the composition of the board. The with the introduction of one person company, there is a possibility that the company can have only a single director also in case of a one person company. Otherwise it is 3-1. There is no difference between the old act and the new act. The maximum number has undergone a change. Maximum earlier was 12, it is now made 15, and beyond 15 also a company can go with the passage of a special resolution. Earlier, if you wanted to have a larger board than that, we had to go to Government of India for getting permission. Now it is not required. We can increase the board size beyond 15 by passing a special resolution. Whether we will have situations where we will have more than 15 directors is a remote question today because of some overwhelming provisions about independent directors. Every company should have at least 1/3 of independent directors. If you have 15 directors, there should be at least 5 independent directors, and 5 independent directors should be sages. Only sages can be independent directors as per the provisions that have been sages. I don't know how many sages can we get in this country today. Okay, so let's see how it goes about. But if at all there is a situation where a company has to have more than 15, it is possible to pass a special resolution. What I foresee is, when you have got companies with multiple partners working together, in such cases, considering the independent directors also into that, there may be situations where you may need more than 15 directors. In such cases, you don't have to go to Government of India and get stuck. To that extent, it's a fairly good relief. And there should be at least one woman director. I am told in SEBI there is a lot of discussion about whether a woman director should be an independent director or woman director itself. They were discussing about Rabbi Devi's case. That is, when Lalu went into jail, immediately Rabbi Devi became chief minister without any winking of the eye. Therefore, it is possible that promoter will bring his wife as woman director is a suspicion. Therefore, a lot of discussion and debate went in SEBI. I am told that whether women director should be independent directors fitting into the various formulas given for independence definition. Whatever it is, even today, even SEBI revised corporate governance norms still retained as women director and non-women director. When we are reading the Companies Act, especially for listed companies, we need to read the Companies Act along with the revised norms for corporate governance hereafter, because at places revised corporate governance norms prescribed by SEBI are a shade stricter than Companies Act itself. Therefore, we need to, at least in the board area, we have got to read revised corporate governance norms also to have the right perspective while dealing with the particular subject. At least we should have one woman director. Mr. Vipul is asking me how many listed companies we have. We have 6,000 listed companies. So at least 6,000 women directors are required. Assuming that 1,000 companies have got some women directors in some form, we need to have at least 5,000 calibered women director readily available in the next 1 year time. I think the rule has been notified for who should be, which class of the company should have a women director. I am sure listed companies will fall into that. And most of the companies having turnover of beyond a particular limit, maybe 300 crores or so, will also have to have one woman director, and therefore there is going to be a lot of demand for women director in this country. And this again, the next question is, at least one director should have stayed for at least 182 days in India. This is, I think, from the perspective of joint venture companies, etc. So even if you have got the board directors who are all the directors are residing outside the country, at least one director should have been resident in India. That's a requirement. And then 1 year time is given for compliance with these norms. That is, within 1 year, at least one woman director should be appointed in all the companies. For listed companies, this is a provision, additional provision given. A listed company may have one director elected as small shareholder manner and terms and conditions will be prescribed. This is an important point. Now, a small shareholder director is also a must for a listed company. It is not clear from the Act at the moment whether this small shareholder director will be considered as independent or not. By name, it is small shareholder director, therefore he cannot be independent. That's one way of looking at it. Other way of looking at it is that since small shareholders are electing, he could be a part of independent directors. There is no clarity, but small shareholders have been given a quota of one director to be elected in a listed company, and a small shareholder is defined as a person having shares of less than 20,000 rupees worth in the company. So 20,000 rupees worth, again, there is a gray area whether it is face value or the market price, but I think it should be face value because that's how the company can calculate. So people holding shares of the face value of less than 20,000 have to elect one shareholder as their director, one director to be placed on the director's board. So that's another requirement for the listed companies, which is again going to be fairly tough, because imagine any listed company's general body meeting, how many of the let's say smaller shareholders will actually attend? So it is possible that a set of 10-20 people will be able to nominate one director onto the board of the company. It's a practicality. It's not envisaged in law, but from the practice perspective, you can imagine in any general body meeting, even if you've got a 1 lakh shareholders in the company, people having 20,000 or less shares, 20,000 worth or less than that, how many of them actually attend? And how many of them will vote? So it is possible that 10-12 people will be able to nominate one director onto the board. This is one reality we are going to face as we go forward in life.
Why this may have, so is it a mandatory thing?
It says that, rated by such as the rules may prescribe. You have to read the rules.
May have one director means, is it a...
It is royal may. May in the act has to be taken as shall probably. Because there are some prescribed rules are saying, we have to read the rule as such. So when the rule comes in, we can understand what's going to happen. But it's specifically for listed companies. So it's possible that it will happen. And at least 1/3 of the board should be independent. This is actually killer. The listed company, at least 1/3 of the shareholders should be independent. We will come to the difference of independent as we go forward. Now, who is an independent director? It's again given in the section itself. Thankfully, definition of independent director as given in the Act and as given in the revised corporate governance norms, both of them are same, and therefore we don't have any confusion about it. Who in the opinion of the board is a person of integrity and possesses relevant expertise and experience. This is the first requirement. The board of directors has to decide whether a person is going to be independent or not, and he should have the relevant, he should be a person of integrity and having relevant expertise and experience. That is the requirement of the Act. And he should not be a promoter of a company. Company is a broad definition here. Company is company itself, or the holding company, subsidiary company, or associate company. I will come to the definition of this holding, subsidiary, associate little later, but this is the way it looks like. So should not be a promoter of the company itself, or should be a promoter of holding a subsidiary company or an associate company, and should not have had any pecuniary relationship with the company in the last 3 years. Again, it's a very tough call. The Act is a little cruel in the sense that there should not be any pecuniary relationship. Say, let us there be a small transaction. Let's say I have engaged a legal consultant for a small assignment, one case, 3 years back, whether he can be the independent director on my board or not. Reading by the Act, probably he cannot become a independent director on the board, even if he has done one case or he has taken one assignment, because materiality concept has not been discussed in the Act. So to the extent he should be completely segregated and should not be associated with the company in any way. We have seen such provision operating in the mutual fund era. When mutual fund trustees are to be appointed, they should not have been associated in any way. That's the word used by SEBI. Therefore, there anyway was stretched to the extent that even if the smallest transaction is done between the company and the person, his association is considered as associate director. Same principles have been brought over here, and therefore should not have had any pecuniary relationship in the last 3 years. Not only that, he himself, none of his relatives should have had a pecuniary relationship with the company. Definition of relatives is given, of course, and none of his relatives should have had a pecuniary relationship. And then by himself or relatives were key management personnel of the company in preceding 3 financial years. Of course, this is a subset of the first condition. It goes further, sorry, what is this? He should not have been an employee, proprietor, partner of auditors, company secretary, legal or consultant, and such firms should have had transactions with the company amounting to 10% of turnover. If any consultancy firm, legal firm, practicing company secretary, auditor, etc., if that firm has derived 10% or more of the revenue from the particular company, then all their partners, etc., will become associate, and therefore they cannot be considered as independent directors. And a person by himself along with relatives holds 2% or more of shares of the voting power of the company, not shares, voting power of the company, then he will again not become an independent director. He is CEO or director of an NGO that receives 25% or more of its receipts from the company or promoters, then again he will lose independence. So this is a kind of a definition. Very broadly it has ring fenced as to what cannot be independent directors, and that's how they are brought in the force of independent directors. This is very wide, and probably finding persons of this nature is very difficult. Usually, as I see in practice, promoters select who should be independent directors, and probably if he likes the person, there should have been some transaction with him also earlier in life, and if that is happening, maybe that people should be cut off. So totally social acquaintances only can become independent directors in after. New corporate governance norms are in alignment with the Act. That's thankfully for us. Now let us understand the definition of associate. Holding and subsidiary company definitions I think more or less we understand, but associate is something which will again far-reaching. Associate company in relation to another company means a company in which the other company has a significant influence, but which is not a subsidiary of the company having such influence and include the joint venture of the company. What is the word influence is not defined. Definition, there's no clarity about what influence can be, but in relation to another company, if the company has got sufficient influence on the other company, that company becomes associate company. This again is area a little grey, and possibly interpretation issues may come up from your fraternity, especially from the fraternity of auditors. When you sit down for auditing and you would like to see corporate governance audit area, if it comes into that, so whether associate, we have to check the directorship held by this person across various companies and see whether there is a possibility of any influence in some form or the other, we have to see. For example, some leader in the firm, leader in the industry will have influencing impact on all other companies in the industry. Does it mean its influence? Don't know. Holding company in relation to holding company, subsidiary company, I think it's fairly easy to, it's a matter of definition, nothing much to discuss about here. There are some other provisions with regard to independent directors. Why did I say that independent director should be a sage? Because of this reason. Independent director shall not be entitled to stock options. He is entitled only to fees, reimbursements and profit share. Not profit share, sorry for the typo, profit share. He is entitled for profit share, he is entitled for fees, and he is entitled for reimbursements. Fees is sealed by government law, so therefore it cannot be beyond that. There is a possibility of profit share of course, but he cannot take stock options. That is, he will not be able to benefit from the improvement in the company valuations. That's what it means. He can never take cash profits from that company, but it cannot take benefit of the valuation benefits of the company. That's a major point here. And the independent director should keep on initially in the first meeting and at the beginning of every financial year, he should declare that he is independent in the company. The independence has to be reiterated by him every year. That is an important point. And he shall abide by the provisions of Schedule 4. Schedule 4 is now already implemented. I will describe about Schedule 4 a little later, but he should be abide by the provisions of Schedule 4. Schedule 4 gives in a kind of a code of conduct as to how independent director has to behave in the company. We will discuss in detail as we go forward. This is an interesting provision. What is he liable for has been defined. I think this is a very good provision from the point of view of protecting the independent director and also providing a clarity as to what is he liable for. Earlier the question was in Satyam and other companies, the law stretches its hands to independent directors also, and to the extent there is some kind of a jittery feeling amongst the people who are independent directors. Even now people say we don't want to become independent directors because of the liability component. But we will see by the particular statement which is given in the Act, shall be held liable only in respect of acts of the company which occurred with his knowledge, attributable through both processes and with his consent, connivance, or where he had not acted diligently. Each word has got a value here. He shall be liable only in respect of acts of the company which occurred with his knowledge. With his knowledge would mean what? Economic Times and Business Standard? No. Knowledge attributable through both processes. That is, an agenda was placed, agenda was read by him, and since he knows in the board process, during the discussions or through agenda, he got to know about a particular matter, and in such a matter, if something goes wrong, he will be held liable. That's a very important point to understand. And with his consent and connivance. Either his consent has been given or is connived. Of course, connivance is a big word. Consent is a moderate word. And where he had not acted diligently. This again is fairly draconian stuff. Where he had not acted diligently would mean what? He should have objected to a particular item if it is placed before the board properly. He should have exercised his mind, understood the content of the particular subject, and he must have said no, yes, sought the clarification, etc. And he must have participated in the board discussion in a way that he is able to he is demonstrating exercise of diligence. This is, I think, very important, because unless we prove all these things, a person with independent director cannot escape a liability for the activities of the company. That's what it means. That's what it means. That is, attributable through board processes was specifically brought into the Act. To the extent it means that if it is not placed before the board, even if he has got general knowledge about it, probably he can always say, I don't know, because it is not formally placed before him. But let's understand one thing, he did not attend a particular board meeting, it does not give him any kind of a exemption in that. He has got the agenda, he has read the agenda. Once he has got the agenda, he cannot say that I don't have the knowledge. Attending the meeting or not attending the meeting may not be material, but as long as the item has been placed in the board, he is responsible for that particular item. That's the implication of this particular thing, called knowledge attributable to the board process and his consent. And he is supposed to record dissent in case he does not want a particular item to go through. He must raise questions. And I think the way in which minutes are going to be written also going to make substantial difference. So long as, until now, generally the practice has been to write the gist of the discussions and come to a conclusion to what discussion was and what the decision is. But hereafter, if a director has said something, that has to be probably big part of becoming a minutes. That may be major difference that we will see as we go forward in life as far as this particular provision is concerned. A independent director shall not retire by rotation. So it does not come into the retirement rotation area, and shall be selected. This is a peculiar provision again. Shall be selected from a data bank maintained by a recognized body. Due diligence to be done by the company. So far, how do you shortlist a person? How do you recognize a person to be appointed as independent director? It's anybody's guess. There is something called the nominations committee, and where does the nomination committee get names from? Nomination committee gets names from the recommendations. Recommendations essentially of the promoter. That's how it used to happen. Our colleague directors in the board. Hereafter, it's not like that. It should be taken from the data bank to be maintained by a recognized body. That is, there will be rules to be prescribed. Probably instead of Company Secretary of India, or a separate database will be maintained by MCA, maybe having a list of names from where the name has to be picked up. Even if you want to pick up a name of your choice, that name should be appearing in the data bank. Probably that's the thought here, and therefore it's not going to be like in the morning walk I met somebody and therefore is coming a independent director. Does not work. It has to happen through the data bank. We have to see who is going to set up a data bank and what kind of processing that is going to come up in this. And then appointment shall be approved by general body. Independent directors should be appointed by general body. This is a very peculiar provision. Having identified a person as independent director by the nomination committee, it should go to general body meeting. It will get voted, of course, no doubt. But anyway, the point is that since it has to be approved by general body, it would mean that the profile of the person is described to the general body, and general body has an understanding of who is going to be their representative of the independent director. Probably that is the intent of the law in this case. Some of these provisions have been okay. All these provisions are fairly same in the new corporate governance norms and the Companies Act. This norm are not much of different. As far as resignation is concerned, is a reiteration of the earlier provisions only, nothing much in this, of course, but some clarity has emerged in terms of effective date of resignation. There is always a confusion as to what is the date of effective date of resignation of a person. It very clearly says that resignation will take effect from the date of receipt of resignation by the company or the date he finished specified by the director in the notice, whichever is later. That is, earlier whether resignation was to be accepted by the board directors as a contention, there is no such requirement. If he has said that I am resigning, it is resignation. The date on which he has submitted to the company or date on which he mentions in the letter will be the date on which he will be resigning from the company. Resignation date will have significance going forward in life, because the directors are held personally responsible for the various acts of omissions and commissions by the company, and unless there's a cut-off date by which he can establish association with the company, he will not be able to protect himself. And therefore, date of resignation becomes fairly important in the life of a corporate body as such. And as far as independent directors are concerned, there is a provision in the new company's corporate governance norms that is a reason for resignation of independent director shall be put on the website and should be filed with the exchange. This is very important and very interesting. What they say is, if an independent director resigns from the boardship, he has to file a letter with the exchange. With the company in turn has to file with the exchange. What SEBI expects, I am talking from a speech given by CGM in charge of this whole subject. What he says is, if a person says, I am resigning on personal health grounds from a particular company, and accepts an independent directorship or directorship in another company in a week's time, 10 days time, then SEBI may question saying that, oh, you are not healthy for this company, your health permits for becoming director in another company, your question mark. It happened, it has come out of a particular example, a particular gentleman who held very high positions in the regulatory organizations in this country, he resigned on health grounds from a listed company which was sinking, and he has accepted the independent directorship of an associate company which is floating. So he was not healthy for a sinking company, he was healthy good enough for a floating company. That's not going to happen. That's what exactly the intent of law over here. Resignation of independent directors, reason for resignation has to be filed with the exchange. Going forward, I suspect that the exchanges will be asked to examine whether the reason given by the independent director is good enough for resignation and monitor his other appointments later on. That's going to happen in future, in our suspicion. Tenure of independent directors, this is slightly a dichotomy between the Act and the new corporate governance norms, therefore I brought the point up here. Tenure of 5 years, 2 tenures of 5 years each is what is available for him. First 5 years he can be appointed with the ordinary resolution. Next 5 years he has to be appointed with a special resolution. The total tenure is 10 years. First 5 years direct appointment through ordinary resolution. Next 5 years through special resolution. And between he can go coming again all over again to the company after giving it 3 years of cooling period. That is, first 10 years he will work, after that 3 years of cooling period, after that he can come back as independent director as such. There is no bar on him to continue the director, but he cannot continue the independent director. Please understand this nuance here. He was a served for 10 years. From 11th year also he can continue to be director on the board, but he will be not called as independent director. That's all the point they are making it. But if he continues to be director on the board beyond 10th year, then he will not get the independent status. If he wants to regain the independent status, there should be 3 years of cooling period. That is 11, 12, 13 years, he will not have any association with the company in any form. After that he can come back as independent director if at all. And the reappointment, the second term reappointment, I am talking about second 5-year reappointment, can be done based on performance evaluation. There will be performance evaluation of the director, and performance evaluation should result into, should direct that, to suggest that he is fit to be appointed again. The performance evaluation report also should be part of the explanatory statement to be sent for the special resolution, based on which special resolution will be passed. So performance evaluation is becoming an important requirement under the Companies Act. As far as the corporate governance norms are concerned, the same things are reiterated but slightly in a different way. Independent director is already serving today. As of today, he is serving as the independent director for 5 years or more already. He can be getting only one more term of 5 years. He can't get beyond that. That is, somebody has been an independent director for the 6th year, let us say today, as of today, and he he can become independent director for another term of 5 years only. He cannot get 10 years. Whereas the Act may think in terms of giving 10 years from the date of making the Act effective, that is 1/4/2014 to 10 years, 2024. The corporate governance norms is not given that kind of a tenure. What it says is from the date of the circular is yet to come about this new corporate governance norms, but the content is already out. Let us suppose for a while that once 1st October is what a date given for the new corporate governance norms to become effective. So from 1st October, other than 1st October, if somebody has completed 5 years of term, from then he will get only for 5 more years, and therefore effectively 2018, 2019 will be a term by which he has to be losing his independent status. That's an important point to be noted. And reappointment shall be based on performance evaluation done by separate meeting of independent directors. This is an important point. In the Act, the performance evaluation has to be done by the whole board. In the Act, the performance evaluation has to be done by the whole board, whereas in the case of new corporate governance norms, it says performance evaluation has to be done by independent directors separately. Now the question is whether the evaluation will be done 2 levels, possibly 2, yes, because whole board has to do performance evaluation and also independent directors have to have evaluation. Maybe the independent directors evaluation will get submerged into the performance evaluation of the main board probably, but as far as new corporate governance norms are concerned, it's very clear that performance evaluation has to be done by the independent directors separately in their meeting. And then how does the performance evaluation happen has to be disclosed in the annual report. It's a very interesting discussion because as such how the performance should be evaluated is not said in the Act and not even the corporate governance norms. But they say you have to do a performance evaluation. The expectation is that as 6,000 listed companies will start evaluating the performance of the independent directors, norms will get evolved by themselves. First year, second year, third year, by the third year, you will find that the whole industry is evaluating the performance of the independent directors in more or less the same broad parameters, and therefore they are allowing the performance evaluation parameters to get evolved over a period of time. By evolution, it is possible only by disclosures, and therefore performance evaluation criteria should be disclosed in the annual report is the expectation of the revised corporate governance norms.
How practicable it is to implement all this?
This was a question asked, and SEBI sharply reacted to saying that we know how to implement. We know how to implement, we ask you the right questions. So what they are saying is comply or explain is the methodology through which they are going to make this implemented. So actually there is a huge shift in the SEBI's thinking also. They are moving from, they are saying that the frameworks created, now enforcement is the way in which is going to happen. They are empowering exchanges to levy penalties and fines left, right and center on companies if they don't follow the corporate governance norms. Already 30th September 2013, there is a circular which gives a list of penalties on companies for non-compliance with the listing 49 criteria. So the same criteria will be applicable, will be made applicable. The fines have got different natures. What they say is that fine on the company, fine on the promoter, freeze the shares of the promoter, move the company from trade to trade. There are so many ways in which they are trying to put the company into this kind of a compulsion. That's what they are saying. And yeah.
It will be difficult for companies to get the independent directors like nowadays after so many liabilities and responsibilities, probably people may not like to act as independent.
Yeah.
So then how do companies can comply with it?
The lawmakers' typical response, which we have heard in the meeting, over a public meeting like this, is that you have to find a way. They are saying they are going to set up a database. You take somebody from the database. There will be database made available to you. Pick up somebody from that. That's what they are saying. It will be difficult. It's not easy.
But if you put the performance evaluation on the public domain, you will also realize that, that it will be a confession that no longer that person is independent.
No, that's the reason why it says performance evaluation of the independent directors will be done by independent directors only. Whereas the Act is not so imaginative. Act says that performance evaluation will be done. It leaves to the full board. Whereas in the case of corporate governance norm, they said independent directors shall evaluate the performance of independent directors. Therefore, independence is protected. That's how they have come to a point. And the criteria to be disclosed in the annual report. the number of directorships, again the dichotomy between the Act and the corporate governance norms, therefore I brought this point up. As for section 165(1) is concerned, a person can be director in about 10 publicly limited companies. Whereas the corporate governance norm says that a person cannot be independent director of more than 7 listed companies. 10 is reduced to 7. This is an important point that we have to note. They have, how did they arrive at 7? There is something called a primary market advisory committee of SEBI. They have done a lot of deliberation and then did some kind of a back of the envelope calculations, time taken for preparing for a particular company, etc., and they felt that a person can devote attention to not more than 7 listed companies if he is an independent director, and therefore they have come to a conclusion of 7. 7 is a peculiar number. Normally we find 5, 10 kind of numbers in the Act and rules, usually, but these people have brought a number like 7 and not even 8. So 7, something sacrosanct.
Yeah, 7 days in a business.
In case a whole-time director serving in a listed company, independent directorship is not more than 3 listed companies. This again a peculiar provision. I am not going to understand this very well. A person is a whole-time director in some other company, he cannot be independent director of more than 3 listed companies. Usually, no company will take a whole-time director of another company as a independent director on the company. Usually it doesn't happen, but they have made a provision like that. One specific provision which I think I should discuss now here is that a person is called as a nominee director is not an independent director. A person who is a nominee director is not an independent director. That again is a very clear-cut provision that has been brought in.
Private limited company.
Yeah?
Full-time director of private limited company.
The whole-time director of a listed company, law is very clear. Whole-time director of a listed company cannot be, in a private limited company he can. Now let us come to the question of Schedule 4. Schedule 4 in a way is a code of conduct kind of thing, like it's like a terms of employment more or less. So I have not brought all the points, you can read the Act by yourself, it's very easy, but I just brought some important points out. What should be the code for independent director? How should he behave in the board? First thing is ethical standards, objectivity and devote sufficient time. 3 important requirements. He should upkeep ethical standards. I am surprised why the independent director is only responsible for ethical standards. All directors should be anyway, that's what the law says. And there should be objectivity in his thoughts and his behavior, and he should devote sufficient time. But there are very vague terms. What is devotion of sufficient time? How do anybody measure? We do not know. But the problem is, these are the words that will come into the performance evaluation sheet in some form or the other as we go forward in life. Therefore, devote sufficient time has got some implication to understand.
Does it mean that he is to attend the office regularly?
Not necessarily. I mean, I don't think if he attends the office every day, it becomes whole-time director, no? It may be actually before also for preparation for the board meeting. And there are some other obligations like training and all that. I'll come to that point. Refrain from actions that compromise independence. Very broad statement again. That is, he should not be doing any action that is compromise independence. That is, he should not ask for a job for his son in the job company probably. That could be one. Some similar things, like wherever he is trying to expect some pecuniary relationship or kind of a reward or some kind of quid pro quo, that should not happen. That's what I am saying, he should be a sage. Help company implement best common governance practices. It's like a Rajguru, do this, don't do this kind of a thing. He has to stand to the company and say, help the company implement best corporate governance practices. So what is best corporate governance? Yeah. What is best corporate governance practices, etc. is not given anywhere, but he has to help the company in that. What is role and function? Independent judgment, objective evaluation of board performance. This is an important point again. As there is something called a group think. When you are sitting in the board of directors, you should not be pushed away from the other director's opinion or as such. If you have an opinion on a particular matter, you should stick to the opinion, you should express the opinion, and you should be objective, you should be independent in your judgment, you should not be carried away by the opinions of the others. Maybe you will get convinced with the arguments of others, but it doesn't mean that 7 people are saying yes, therefore I should say yes. It should not be the way in which you should behave, and therefore independent judgment is one important point. And you should be participating in objective evaluation of board performance. Whenever board performance is being evaluated, you should objectively contribute to that. scrutinize the performance of management and satisfy internal controls. Sorry for typo. Satisfy about internal controls and risk management. There is a specific responsibility of internal controls. I'll come to that a little later. But here it says that he should scrutinize the performance of management. This is a very important point. In the first point he said objective evaluation of the board itself, while in the second case is scrutinize the performance of the management itself. That is, when the information about the performance of the company comes in the form of board agenda in different forms, or in the audit committee agenda, or in either specific business committee agenda, he has to scrutinize the performance. Scrutiny, it's not study, it's not assessment, it is scrutiny. It's much deeper. He has to evaluate objectively, he has to study in depth about the performance, and maybe he has to satisfy himself that the internal controls and risk management are robust and very much in place. And then safeguard interest of all stakeholders and avoid conflict of interest, etc. Adding some, sorry for the typo. Safeguard in the interest of all stakeholders and address issues of conflict of interest. This is another important role and function. Duties, here important, a sufficient time point comes over here. Undertake induction. He has to undertake induction program for himself. If he has been appointed as independent director in a new company and he does not understand the business models of the new company, he shall devote a time to understand how this business works. He has to devote time, he has to induct himself into the company through a particular program, update his skills relevant to the company, knowledge, seek clarifications. This is important. He has to seek clarifications. When we seek clarification, somewhere else it says that whenever he has a question, the independent directors shall have the right to appoint external experts to get the information out from the company or have assessment of a particular agenda item before them. That is, they should exercise their independence and say, my dear company, please spend so much money on this special expert to help us understand in this particular business phenomenon. That kind of what you call independence they have to exercise. Therefore, they have to seek clarification, strive to attend all the meetings, participate constructively in the meetings. Participate constructively in the meetings is read with one more word, not to intentionally obstruct proceedings. That is, you can only be sage, you can't be a blackmailer in the boardroom. That is, you can't keep on obstructing the business proceedings in the boardroom by obstructing it to the extent it can be a part of performance evaluation, whether it is constructively contributing to these business meetings or is obstructing the board processes. And ensure board addresses all concerns and minutes are recorded accordingly. These are very broad words, Ensure board addresses all concerns. When you say a board addresses all concerns, an agenda item comes before the board, it is not that board should be carried away by what the management is presenting. They should be able to imagine concerns around. It's quite possible that the management will present only the picture they would like to present before the board. But board has to exercise diligence, objectively use their expertise and skill and ask for unravel the areas which are not explored or say presented by the management. That's what is expected. Therefore, it's a very broad area here. Independent directors' responsibilities are far higher. If the courts start interpreting principles based in this particular code of conduct, possibly every independent director will get into some kind of a court scrutiny as we go forward in life. Manual appointment, every independent director will be appointed in independent process through nomination board. They should be approved by shareholders. A letter of appointment to be given. This is an important, interesting part. A letter of appointment is given to the independent directors, and that letter of appointment is to be shown to the shareholders. It should be part of your disclosures, website disclosures, annual report disclosures, disclosures to exchange. What are the terms and conditions on which an independent director has been appointed has to be made public, and that appointment letter will say remuneration given, do's and don'ts, etc. and terms and conditions are prescribed transparently. That is, the role and responsibility of independent directors are very transparent and openly described to everybody. This is a part of the act itself, therefore every company has to necessarily follow. And then reappointment is based on performance evaluation. Resignation removal, he can be removed only by ordinary resolution, and if there is a vacancy in the independent director's position within 180 days it has to be filled in. All the independent directors have to meet separately once a year. It's a mandatory requirement. Independent directors should have to have a separate meeting of their own where the whole-time directors or the shareholder directors do not participate, where they can freely discuss about various concerns about etc. This is a mandatory requirement of the code of conduct, and then the whole board should evaluate the performance of independent directors. This is a peculiar contradiction, whereas in the corporate governance norms given by SEBI says it should be done by independent directors separately, whereas the code of conduct says shall evaluate performance of independent directors. This is a dichotomy, but this is what we have to live with. Evaluation is an important requirement in the independent directors chapter.
The separate meeting of independent directors, will it be a board meeting or it will be a separate?
It is a separate committee kind of meeting. It should be a separate committee kind of meeting.
Because there is no committee like committee of independent directors technically today.
That is right.
Either you are audit committee.
It is not even a committee. It is a meeting without probably any agenda. In fact, we had in NSC we did a meeting like this. One, there is no responsibility for the executive. There is no agenda also for this. Because if you are trying to say agenda, you are conditioning the mind of independent directors. Therefore, independent directors, the company secretary will have the responsibility of saying, sir, your meeting is held now. Please convene for this day. I have checked with all the directors. They are available for this. Please meet at so and so place. It is for the chairman to decide. There is a concept of lead independent director. It's not coming out anywhere in the discussion papers yet, but I am sure lead independent director concept will come up in life. But lead independent director will decide the venue where they are going to meet and convene. Maybe company secretary will help in ironing out the diary differences. So the moment a convenient date and time and decided, the independent directors will meet there. Agenda not known. Minutes probably have to be kept. If the lead director says minutes have to be kept, company secretary will have to go and record it. That's how it's going to happen. It is expected that company secretary is an independent person by himself, and therefore he will have to keep the minutes. That's right.
The remuneration of the independent directors, remuneration of the independent directors is based on the performance evaluation.
Not in the sense of an employee's this thing. Remuneration is decided and passed by general body. So that's what it says. You can't say that since you are not performing, you will get 70% of your salary. No, it's not like that.
Then what is the base for performance?
Performance evaluation is essentially for whether it's fit for reappointment or not.
Only for reappointment.
That's right.
That's all.
Yeah. There's no other way. Performance evaluation criteria is given. Going forward, I will not be surprised. Within 1 year or 2 years of this kind of rule, they will say that performance of the independent director shall be disclosed in the annual report. That will come. So after that, a particular independent director is performing well or not will be known to everybody. And after once it is in the public domain, people can assess, understand whether they can continue or not continue. So that's how it's going to be.
Professionals with dignity would like to be part of this kind of public evaluation process.
That's what you observe, no? It's very difficult to get independent directors, is the problem. But that's what I'm saying. He should be a sage in the sense of the term. Completely, not connected with anything. ठीक है, हम जाते हैं, उपदेश करके आ जाते हैं. That's what kind of going to happen. I don't know. Yeah?
Vidhu is a good person for you.
That's what I'm saying.
At present, who are the independent directors mostly?
If you are talking at present, people who are known to promoters are independent directors. To be very blunt. Usually what they are doing is they are taking experts in some areas like audit, accounts law, or subject matter experts particularly relevant to the industry. They are taken as independent directors and taken on the board. There is an article by, I think, Suchitra, some 10 years old. She says that people who can add glamour to the board are independent directors today. They are nice, not obstructive, don't question, good names to have. This kind of people are independent directors today.
What I have seen in the newspaper, mostly they are retired chairman of some public limited or public sector bank like that. They are independent directors.
That's right. The very purpose for which they are taken, their first thing is, if they are retired in such high positions, they have got some expertise. Let's not question that at all. And then they have reached the status, therefore they must be having fairly good integrity too, probably. Okay. Third point is that they are able to be good survivors. That is, they are able to survive under all conditions. They are nice people. They can give advice. They don't mind if the advice is not taken.
Number of such people are there, why there is shortage? Number of such people are available. So why there is shortage?
I think the actual dilemma with a promoter is, can you bring an unknown figure and keep the vacancy in the board meeting as such? It's very difficult. Because we discuss so many things, we don't know the person, where is he going to talk, what is he going to talk, how much of boardroom secrets will go out of the room, we are going to share the business models, we are going to share profit and loss, projections and project details. If they are all given to an unknown person, if you have no control on him, we don't know how he is going to behave. He should be a person with integrity, but disclosure, I always speak truth, and therefore I speak the truth of this company everywhere wherever in the public forum. Is it right? There should be some discretion and probity. We don't know. That's the reason why promoters select people who are at least able to keep the confidentiality in the board meetings. That we are not guaranteed anymore. If you're picking up somebody from the database and put him over here, we don't know what is he working for, what is the agenda, we have no idea. This is a real question. And then additional provisions from the corporate governance norms. These are again peculiar, additional responsibilities. I am saying peculiar because I heard SEBI saying that exchanges will have to monitor whether all these things are being done or not. Imagine this. Appointment data of the ID shall be disseminated to company website, exchange website. Detailed profile of ID shall be disseminated to company website. Detailed profile should be given. Companies to provide suitable training to independent directors. Now imagine what is a suitable training. And will a independent director be amenable to a classroom type of training, on-the-job training? What is the training? How will it come? The answer to the question is, over a period of time it will evolve. But let us put this provision, therefore they have put a provision saying that company's responsibilities is to provide training to the independent directors. It is coming out of corporate governance norms, therefore it becomes binding on listed companies to do this. And then companies to familiarize ideas with their roles, responsibilities, rights, nature of industry, business model. They have to induct the independent director and give him all these informations. And details of the training given have to be disclosed in the annual report. So, disclosures is the way in which you are getting bound. Have you done training or not? How exactly it is? We have a difficulty. Actually, I am sharing in this room. We do conduct training programs for independent directors on the National Stock Exchange. They are all 70, 65, 70 plus and very high order people. I mean, we generally take training from them. And so, we have to give training to them. Who will train? Are we talking about the subject matter expert in the company, that is an executive in the company go and training? Very difficult. I mean, and then how much can he disclose, how much can he talk to him in terms of training? It's difficult. The answer to this question was, it will evolve, let us wait for this particular thing to evolve. Therefore, let us have this provision, they have this provision in the law. Yeah.
Until it all gets evolved, there will be a lot of lapses. What are the consequences in the sense that if some of these things are not, norms are not complied with, the consequences are on the company or on the independent director or on the board?
I think whatever is very clearly on company, it will come on company only, and then independent directors, it will come in the performance evaluation, if at all. So most of the time, the company will be responsible, advise, warning, all this will happen initially.
Mutual fund industries are there this concept of training of the independent directors called mutual funds.
Yeah.
And I'm not sure which organization, there was a training government body which had conducted during the year various programs for
trustees,
independent directors and trustees of
mutual funds. Yes.
Something like, and all those enrollments for that were sponsored by the companies, I mean the mutual funds.
Yes.
For the independent.
It was done by National Institute of Securities Market. NISM has done that, which is a SEBI's body itself. They have done it. They have done it a big way. What we understand in the market response is 2-3 organizations are coming up which are going to specialize in training of independent directors. They are coming up with that. The complexity as I foresee is that a general understanding, you can always create a training program, a seminar can be conducted. But then, let us say petrochemical industry, automobile industry, a person who is a chartered accountant or a lawyer, he has to go and understand how petrochemical industry works. So how can you have a petrochemical industry training to a chartered accountant, a lawyer or a company secretary to be able to talk in equal terms with the expert in the petrochemical industry? It's very difficult. So what is that you're going to train him? What is it going to train him? The only point I'm saying here is that Possibly, if the training is to be done by the internal experts, they will reveal only so much that they can catch the impression of the person, not to say other things which are going to be very complicated, which they want to actually keep back. Whereas an outsider will do, probably he will open up all that and let him know. We should see, it's a very interesting thing to watch. Now we will shift to the audit committee. From independent directors area, we will go to the audit committee. Every listed company to have an audit committee with at least 3 independent directors. This is a first and foremost requirement. Peculiar law, look at the law, it says 1/3 of directors should be independent directors at the composition point of view. Okay? Here it says at least 3 independent directors, a matter of section itself. 177 says at least 3 independent directors. What does it mean? It means that board strength should be not less than 9. This is a drafting error. I mean, they should not have said it. But anyway, it should be majority of independent directors should have been much better. But they said at least 3 independent directors. If you have 3 independent directors, then board strength should be at least 9. Because 1/3 should be independent directors. They tend to force it. They have not seen the reconciliation probably. That's one observation we have to see. No, I am talking about the size of the board. Size of the board, it says 3 to 15 is the size of the board. But when you say that at least 3 independent directors should be there in the audit committee, so you are expecting 3 independent directors in the company. If you are expecting 3 independent directors, board size should be at least 9. Yeah. 1/3 should be independent directors, no?
Board also
Any more.
So 2 directors and 3 independent directors.
Possible. Okay. Fine. It is possible. You are right. So then, what is the scope of independent audit committee? I think it's more or less a replication of the earlier act. Recommend and appoint auditors, review and monitor independent auditors, examine financial statements auditors report, approval of related party transactions. This is a peculiar deviation which I think all of us have to spend a minute on. So far, audit committee has been a review committee. It has never been an executive committee. Here when you are saying that I am going to approve related party transaction, you are giving executive power to audit committee. I do not know whether it is a correct thing to do or not. On a review committee, you want to bring an approval authority is a big question mark in my mind. And secondly, from the point of view of expediency of business, if it has to be, somewhere it said prior approval of audit committee. If every related party transaction has to be having a prior approval of the audit committee, it would mean that you have to have audit committee approving the transactions may get stalled, or there is a need for holding audit committee more frequently. It's again fairly, business point of view, it's a problem area. It's a peculiar provision they have brought in. This has been reiterated by the revised corporate governance norms also. This is a peculiar problem we are going to face. And then, yeah.
Can the audit committee pass omnibus resolution creating a particular limit for related party transactions?
Transaction has to be approved. It's not that all related party transactions to be entered into the company are approved. You can't pass like that. Actually, I'll come to that point actually. If you look at that 188, it says that transactions at arm's length in the ordinary course of business can be done by the company itself. There's no problem. That's not an issue at all. The issue is, let us say the project execution comes in. NTPC is trying to execute a project, for example, and BHEL is trying to do the project. If you look at the association, if you look at the extreme steps of common directorship, common shareholding and all that, NTPC and BHEL become associate companies because common shareholding by Government of India. So is it become a related party transaction? The related party transaction has to go to audit committee to get approved. You can't execute the project at all without prior approval. These are the issues to come up. And then scrutiny of independent loans, investments, valuation undertakings, evaluation of internal financial controls management systems, monitoring efficient use of funds through IPO, cause investigation. These are all the normal conditions. Approval related party transactions is something which probably we have to flag as a new learning in this particular area. On internal audit, I think we need to spend some time. this, it says actually, if you look at the bill itself, it says that we don't want Satyam episode to repeat again, and therefore we want to bring internal audit with a statutory force. Internal audit has been given a statutory force in the new Companies Act, is very important. In the area of corporate governance, audit and internal control are going to plug the gaps in. Section 138 has specifically inserted a new provision in the Companies Act. It says, such class of companies as may be prescribed shall be required to appoint an internal auditor who shall either be a chartered accountant, cost accountant, or such a professional to conduct internal audit of the company functions and activities of the company. That is, internal audit has been given a statutory force. Internal audit has to be appointed. Every company, such class of company will be prescribed. Rules will say, again it will go by the turnover requirement. All listed companies will come into this. All larger companies will come into this. More or less all companies will have an internal audit function, which is all statutory force. And then central government may also prescribe internal audit formats, the format in which internal audit may be reported to the board. So that is the extent to which the Companies Act is trying to bring in force of statutory force internal audit. This we have to reckon with. And board has been given a specific responsibility to respond or react to internal audit in specific ways. It says, 134.3.1 says, a statement indicating development and implementation of risk management policy for the company, including the identification therein of elements of risk, if any, which in the opinion of the board may threaten the existence of the company. If you look at the objective of internal audit function, essentially internal audit function is the assurance function, that the company can continue to exist under all conditions. The internal structures are so strong that company can continue to exist. So threaten the existence of the company, this is a very broad word. Existence of the company can get threatened because of multiple reasons: business reasons, legal reasons, competition reasons, policy reasons, so many reasons. So from all angles, it has to be seen whether the company's existence is not threatened, for which what are the elements of risk. All of them have to be, so state the board responsibility. Board has to declare in its annual report that it has reviewed, it has assessed, is understood and seen that the company has implemented risk management policy in such a way that the company's existence is not threatened. It's a very broad statement, and therefore board will have to get definitely involved into internal audit function in a big way. In the code of conduct, independent directors has been given a specific responsibility of saying, satisfy themselves on integrity of financial information and their financial control systems is found are robust and defensible. In Satyam, if FDR certificates were not checked, but FDR entries have been made in balance sheet, independent director cannot say, oh, auditor has done it. No. He has to say that there is a risk management practice, there is internal control, the audit practices are so strong that the auditors have checked the veracity of each entry in the balance sheet finally, or each entry or each activity with the internal control processes. That is the extent to which the code of conduct is binding the independent director. The very important point to note. It's not easy to get over this.
That means independent director has to get a certificate from the auditor whether they have checked or not.
It is not enough to get the director certificate alone. He has to probe. He has to raise the right questions, seek clarification. That's what code of conduct says. In Satyam, yeah, internal auditors have signed, the auditors signed, everybody signed, no. But still, they said they want to plug the loopholes of Satyam, and therefore internal audit has to have that kind of a probing. I would feel, a matter of 3-4 years, right through visionary, is that you are given iPad, you have got agenda item, why not you have all the internal audit related information that internal audit gets onto your machine and look at it. That's what they are going to say going forward. Independent director's responsibility is going to go substantially higher in this now.
Yes, sir, the way minutes are drafted, they do not record every single conversation in the board meeting. For example,
as of date.
Board directors have asked certain questions. In the minutes will say board discuss the matter.
That's right.
Ultimately approve the project.
That's right.
But I think the way the things are going, every single conversation, maybe it will have to be recorded.
Yeah, if I'm an independent director, if I raise a question, I expect that the question raised by me is recorded in the minutes. Because performance evaluation, and to protect myself, I've done my probity, I have asked the clarifications, I have done my due diligence. How do I prove it? So board minutes writing will be changing completely now.
The whole scheme of writing the minutes now
we undergo a change, no doubt about that. And director's responsibility statement should say that this company has laid down internal financial controls to be followed by the company, and that such internal financial controls are recorded for operating efficiently. Directors should say, I have laid down, they are working efficiently. How will they say that? Unless they have extracted relevant information from the internal auditors, they cannot say all these things. That's the kind of responsibility that's expected out of the board of directors hereafter. So internal audit is trying to take a totally different dimension altogether. We'll come to the related parties transactions. If you look at 188, there are simply three types of related parties transactions. One, RPT is entered in the ordinary course of business. What is ordinary course of business is not very clearly defined. RPT is entered in the ordinary course of business other than transactions which are not at arm's length basis. That is, ordinary course of business, you have the transaction, it's an RPT, it can be done by the company, there is no problem about it, there is no objection to that. Only thing is, if they are done at other than arm's length business, it's a problem area. It should be done arm's length area. For example, I have a company, I have a lot of premises with me, I want to give a part of my premises as for rent for my subsidiary company, I can give it, I don't have to take anybody's permission for it, I can do it, provided I charge a rent which is fair rent. That's what it comes to. I can outsource some of my work to one of my subsidiaries. I can do it, but the quid pro quo for that should be fair, market related. That's what they are trying to say. Therefore, this ordinary course of business is. If you Google for ordinary course of business, actually you will get a lot of very interesting results in that. I am a manufacturing company, and I am not in the business of renting premises. I have some spare area which I can give on rent. If I give on rent this spare area, is it ordinary course of business or not? No. And therefore I have to go to the board for approval. That is, I have got 500 square feet of area in Narasimhan Pond area. I have got a project in Pune which is manufacturing automobile parts. If I have 500 square feet of spaces to be given for rent, it is not ordinary course of business for my business because I am a manufacturer of automobile parts, and therefore I may have to consider as a RPT. So what is an ordinary course of business or not is going to be a very big question mark that probably your fraternity, especially auditors, will have to struggle every time. Ordinary course of business for that particular business, is it ordinary or not, is a question mark that you've got to give. Ordinary course of business is not defined, not explained in the Act. Yeah.
The arm's length price is determined in the Companies Act. But suppose tomorrow domestic transfer pricing officer says that some addition has to be done after 2 years, will it be against the arm's length price or what?
If it's going to be if you are able to establish arm's length by your documentation, probably it should still be fine.
But the ITO at the domestic transfer will say that there is an addition because it's not arm's length.
I don't think it will be held against you. I don't think it will be held against you.
Of his view of the officer, I don't think so. That will anyway dilute your sort of
responsibility for arm's length.
Responsibility, or to that matter, even any disciplinary action here.
Yeah. Then RPT is to be approved with the approval of the board. There are some 7-8 items which can be done only with the approval of the board, but it should be by way of resolution passed in the board meeting. It cannot be circular resolution. It has to be board resolution passed in the board meeting itself. There are 7-8 items given in the Act itself. There is no issue. And third one is RPT is entered with prior approval of the company by a special resolution. Other things, first the items that are not falling in 1 and 2, there can be done only with the prior of the company by a special resolution. We have to go to the general body and take a special resolution for it. The third one is a fairly burdensome thing. There is a rider on this in the revised corporate governance norms. I will come to that little later. This is the related party transaction definition given by the corporate governance norms. This definition is not in the Act. What I am going to speak now is not in the Act. It is in the revised corporate governance norms. Therefore, all listed companies will have to follow this particular related party transactions. Related party transactions as defined by SEBI in the revised corporate governance norms is fairly stringent and fairly, I would say, clear in a way. What it says is a related party transaction is transfer of resources, services or obligations between a reporting entity and related party regardless of whether a price is charged. Regardless of price is charged, this is common practice. That is, holding company, subsidiary company, some functions like accounting, some functions like HR, etc. are commonly done. So they all becomes automatically related party transactions. because these are trying to render a service. Therefore, what are the approvals required for that has to be done. This is the kind of a implication for this particular statement. A related party is an entity, is a person or entity that is related to the reporting entity in different forms. Here there is given details of how two entities can be considered as related to one another. I think it's fairly understandable. There is nothing, I would say unimaginable. Everything, whatever can be imagined as an association has been brought over here. The only point is that this definition is not as a part of the Act. Definition is given by the revised corporate governance norms that we should be aware of.
It is a disjunct.
Yeah.
The Act gives 188.
Yeah.
Governs.
We have to read along over and above that this has come. This is what the problem is. And then what is that? What are the policies? All companies to prepare a policy on dealing with related party transactions. This is again coming from the revised corporate governance norms. What it says is that all companies should have a policy. Now, they go to say, if you say that I have got a policy on related parties, not sufficient. The policy should say A, B, C, D, E, F. What are they? Criteria to decide what is RPT, its materiality. It has to be prescribed in the policy. Whether it is arm's length or not should be disclosed. Approval levels for RPTs has to be disclosed. What is the level of disclosure has to be disclosed. Why is it beneficial to the company to have RPT has to be disclosed. And level of approval for each type of RPT, that is whether board will approve, audit committee will approve, who will approve, etc. should be very clearly stated in the policy. So annual report of the company should disclose the policy towards related parties is a requirement. And such RPT policy should be on the website also. In addition to annual report, it should be on the website also. The Companies Act says that audit committee shall act according to terms of reference by the board, which shall include approve subsequent modification of RPTs, whereas the proposed corporate governance says all RPTs require prior approval of audit committee. The word prior approval is not mentioned in the Act. Whereas revised corporate governance norms are using the word prior approval. It's a huge difference. And then the revised corporate governance norm says that companies should have a policy for determining what is materiality. Act is not envisaging. Act is not distinguishing between what is a material RPT and what is a non-material RPT, whereas the revised corporate governance norms are expecting that you will mention what is material RPT as such. So materiality definition has to be specifically brought in to the requirement under the revised corporate governance norms. And then the material RPTs have to be disclosed to stock exchange on a quarterly basis. This has to be disclosed to the exchanges. I can easily imagine that once something is disclosed to exchange, SEBI will say, my dear exchange, please ask some questions to the company. This goes on. This cycle is on now. One more thing is, this is again an important requirement. Section 188 of the Companies Act says, approve RPT resolution related parties abstain from voting. What it says is that in the case of a special RPT, related party transaction, it has to be approved by special resolution by the company, wherein related party should not be voting. In practical terms, what's going to happen is, if promoter is holding a 50% or 60% or 50% votes, he should not be voting in it. And you will find a few shareholders deciding whether a particular RPT should be conducted or not. It's actually going to be fairly impractical situation going to be, because we have seen in a company having about 1 lakh shareholders, actual number of shareholders attending a meeting will be 30-40. Those 30-40 people will decide whether RPT is going to be approved or not. So to swing the mood of 30-40 people is not difficult. I mean, it's going to be tough, not easy. And then the revised corporate governance norms have specifically said certain things. What it says is that the companies have to have a policy to determine material transactions, and materiality threshold broadly they have indicated is individually are taken together exceeds 5% of the annual turnover or 20% of the net worth of the company. Anything which is about 5% of the turnover of the company or 20% of the net worth of the company is considered the material. I think it's a fairly big threshold from the point of view of threshold perspective, but very clearly it does not cover those transactions which are material but not expressing quantum of money. That's again not specifically covered, so we should see how that will be handled. Now we come to the towards it. Yeah?
We have still a lot of time, I said.
But what is it for?
You want to break for some time?
That's okay, that's fine. We'll finish off. Tea. The other provision, KMP, this is a specific point I want to make is that the key managing provisional persons have been specifically identified. And not only that they are specifically identified, they are made specifically responsible also. They are made specifically responsible also. That is very, very important provision in the particular Companies Act. What they say is that CEO, Managing Director, Company Secretary, Full-time Director, Chief Financial Officer and Successor Officer as may prescribed are called as key managing personnel. These are all the key managing personnel. Let's understand from this fraternity point of view, Company Secretary and Chief Financial Officer sit along with CEOs and Full-time Directors in the company. Let us congratulate ourselves for that. Okay. And then what are the provisions for this? KMPs are officers in default and attracting fine and imprisonment, not improvement, imprisonment. There are various provisions in the Act which says there will be fine and imprisonment as a consequence of non-compliances, and therefore KMPs will be in problem. And especially, I am sure CFO and Company Secretary will be in highlight because most of the time responsibility for compliance is on these guys, and therefore their neck is very much into this stake, and therefore we have to understand how we behave in this company hereafter. Every company in the prescribed class should appoint full-time KMPs. There is no choice. There has to be full-time companies, and KMP has to be appointed with the approval of the board. Board resolution is required. These are all very important points. When you say board resolution, there is independent director, there is a probity, due diligence by the independent director, due diligence by other directors, they make 110 questions before a person gets appointed, and therefore a lot of scrutiny is going to come up. And then a KMP cannot hold office in more than one company. It can be only in one company as such. And vacancy in KMP should be filled in about 6 months' time. And contravention of the above, that is, if the KMP is not appointed, it will lead to fine on the company and directors also. Directors also will be responsible. If a company does not have a company secretary, if a company does not have a CFO qualified for the purpose, and it's more than 6 months, the company and the directors, please understand, the directors also will be responsible for not having filled the vacancy, and to that extent a fine can be imposed on the directors. This is the provision for KMP. This is what I wanted to broadly cover, and we can have discussions. Yeah.
If the company has 6-7 subsidiaries, then whether a KMP can be appointed as KMP of the holding company and 6
It says that KMP cannot hold office in more than one company at the same time except in its subsidiary company.
one company or any number of
Language is subsidiary company. Act is not saying companies. Actually saying only company. And I don't know whether we should read it as a plural or not. It says company. I think we can be taken as a generic noun, and therefore we can use companies in that. We can read it as such. That's what my personal opinion is. I don't know how legal humanities will read it.
MD can be appointed in main company and
There is a specific provision for that. For that there is a specific provision. As far as KMP is concerned, he cannot be in more than one company, except the exception given to is he can be in the holding and subsidiary companies. That's the specific exemption given. Yeah.
What do we do the related party transaction if you know 100% party?
Okay. They can, let's understand, there is no bar on liquid transaction as such.
There the shareholding is 100% owned by the parent company. They cannot part the investment.
Okay, they cannot participate at all.
They cannot participate.
where there are only 2 directors and they both are the shareholders. What in case of that company?
I think such private limited companies are do not fall into this criteria. There is no exemption given anywhere. For listed companies it is more stringent. For other companies, for class of companies is what they said. We should look at rules for that. Probably we can get some relief. We should look at rules for that. We don't have rules as such with us.
Director who is planning to find the letter charge in 30 days. Is it physically you have to find or?
upload it. I mean, I don't know the form as such, but then, but I think there is a method of filing annexes also to that. Scanned copy of the letter can be uploaded. Already I think some rules have been notified today. Yeah, I have not read it. Today, yes.
Dated yesterday, yes. About this number of limits, number of directorship, 7 or 10 as the case may be. The corporate governance code also requires that independent director sitting on a board of a listed company should also be sitting on a significant subsidiaries, the major subsidiaries of a listed company. Would that number also be counted for this, or is it only the listed companies?
Listed companies. Very clearly, as a corporate governance norms is concerned, listed companies. Company that says companies.
So when it comes to 10 companies, 10 public companies,
if subsidiary is also a listed company, then you will lose the count. Two counts will go.
Subsidiary may not be listed companies, but subsidiary is not listed be a public company.
If it's not listed, you have the relief. One listed company and subsidiary is not listed, you will exchange over relief.
We will have drafted in the Act, I think leave some grey area for.
And Act says companies.
Limited companies.
Act says companies, whereas listed companies is a word used by the corporate governance norms. So a person can be 7 listed companies plus 3 non-listed companies. That's how we should look at it.
Thank you, Dr. Narasimhan. Friends, we have a lot of time. The next session is going to start at 5:30 and you finished maybe 15-20 minutes before time. So we still have, he is going to be here for some time. But I think having seen your presentation and having learned the provision, I think it's going to be a challenge, not only for the companies, but also, for professionals and the independent directors most. I think they will all have to, do a lot of documentation to justify that they have done their job right. I think, I don't know, they are talking of integrity, the person who are involved in drafting of the, whether their integrity is so good. Our ministers or our politicians, I think this should be applicable to them also. But nevertheless,
one concern which I have, and I think it's going to be real also, is matter of 1 or 2 years maximum, you will find lot of enforcements coming from different corners. NCA will get active, SEBI will get active, SEBI will activate exchanges to ask lot of questions, because in this act we have ability to reach to the person and ask questions to him. Company secretary, chief financial officer, auditor, we cannot handle questions. So if there is something going wrong somewhere, if something is reported to be wrong, not necessarily wrong, without probity, without understanding what the realities are, without understanding facts, you will be asked to explain a lot of things. This is going to happen because the regulators are very active, and the Act empowers them to ask these kind of questions, and therefore you will find that anybody in the profession, anywhere, in any form, if it is a KMP or independent director or a professionally serving a company, we will have to do a lot of answering, and our documentation has to substantially improve. Whatever the audit comments we are making, whatever the minutes we are going to write, whatever the notes we are taking, what the participation we are going to do in the company meetings, all of them have to be substantially documented to protect ourselves. Otherwise, if you depend upon goodness of people around, it's not going to work. Definitely it's not going to work. As you said rightly, the way in which minutes we are going to return is going to be completely different. I am not surprised. What do you say?
Absolutely right. Nowadays must.
Yeah?
Yes. Like it.
You can,
some of the AGMs are being recorded. No?
Yeah, there's no bar on recording as such. There's no bar on recording. Maybe chairman's permission is required. If the video conference based, anyway you got to record. Anyway you have to record. But in other meetings, which are physical meetings, whether recording can be done or not, is the prerogative of the chairman. Chairman can decide. But the minutes, even the written minutes, have to be recording all those things very clearly.
There will be constant dispute. Like I said something and you will be recorded.
It is possible. It is possible.
Absolutely.
It is possible that directors will keep on questioning the company secretary as to what he has recorded, what he has not recorded.
With this training for independent director, would it be mandatory for a person who is a seasoned independent director, say somebody like Deepak Parekh, for example?
Yeah.
He is appointed as independent director on board of some company. So would he be required to be, imparted training?
Yes, I'll tell you why. If he is appointed as a director, independent director on a housing type of company, maybe he doesn't require because he's an expert in that. But he's going to be in petrochemicals, automobile spare parts,
Sector.
IT, sector, we don't know. And then there should be a record of how many training programs were conducted, who attended, whether the director attended or not attended, all these questions will come up.
And what about the directors who are already there on the board? Would they be required to comply with all this in a later date?
Yes. Okay. Yes. Therefore, if somebody wants to set up an institute for training in directors, it's a good opportunity.
Don't get surprised, there is going to be CT everywhere.
Sir, you mentioned that for independent directors, whatever is put forward before the board, and even if it is on the agenda, it becomes the responsibility of the independent director to write it or at least analyze it. What happens if there is a communication by the board, independently, just emailing them and marking them on emails? So whether they will be held responsible for even things which are not...
So we have to see the word through the process of board.
Okay, so
through the process of board is important. If the chairman instructs that all the directors be updated with this particular circular on subject, then it becomes the process of the board. It happens, for example, we are in the financial service in the insurance industry, IRDA comes with a new rule and chairman says, my dear company secretary, please inform all the directors about the new rule. So therefore, the director cannot wriggle out. He has to accept the responsibility of having understood the rule. Does he understand?
Sir, based on, since exchange would be monitoring by and large in spirit this thing, can you guide us on specific verifiable objective criteria for performance evaluation based on the current practice?
Actually, that thing is evolved as yet. We don't know what's going to performance evaluation as such. But as I see it, we can evaluate only on the basis of what is disclosed to the exchange.
So verifiable, specific, and objective.
I would feel
is matter of subjective.
I would feel whether he has participated, whether contributed, he has made his statements in the board, what are the, how many times attended the meeting, how much. So that kind of questions will come up.
In one case, it was discussed that if the audit committee chairman and couple of independent directors meet the management day before audit committee. Normally, audit committees are so framed that half an hour after the board is there, or 1 hour after.
Correct.
So they meet the management for a half a day or full day, earlier day or 2 days before. The corporate world calls it pre-board meetings, which are informal. If that is done and some record of that is kept, can I take a plea on that my being objective, my asking questions, not necessarily at the meetings, at the proceedings of the meeting, but I keep asking questions management this manner also.
But how do you record it? How does he record it? He has to prove it somewhere, no? He has to prove it somewhere.
Practice will start now where board meeting days and audit committee days will have to be separate.
Will have to be separate.
Because the way these responsibilities are cast on the independent directors, I don't think so we can have this half an hour window or 1 hour window to discuss all those aspects, and that too in detail and with notes, with things being properly minuted. It is just on minutes. Most of the time when we attend the board meeting, minutes are the minutes of today's meeting. We will see it in the next agenda paper, which will be somewhere after 3 months of this today's date.
Yes.
So you will also, as an independent director, will have to maintain a very minute record of what you had discussed, because after 3 months we would have forgotten. So it's going to be a big challenge, and I think as somebody said, most of the independent directors who are living his own conscious life will
or at least not for this money. Not at least they will ask for higher fees at least. It's going to be deterrent. It's not going to be easy at all. It's not going to be easy at all. Actually, if you may be knowing this, one group of companies which is having about 6 companies, 6 listed companies, it came in Economic Times. It's India Bulls Group. what happened was they had 6 AGMs of listed companies in a span of about 1.5 hours. From 11 o'clock to 1 o'clock, they wanted to complete 6 general body meetings. SEBI insisted that we should ask the company as to how did they conduct 6 general body meetings in a span of 1.5 hours, 2 hours. And still correspondence going on. Company says there was sufficient time for me to do all these six meetings. And we are asking how is it sufficient for you? So this tussle goes on. It's not going to stop somewhere, but this tussle become a statutory tussle hereafter because the provisions of the Act. These questions will come up. I have to review. The independent director has to say that I have satisfied myself that internal control mechanisms are robust enough and company's existence is not threatened. How does he make a statement like that? Where does he make the statement from? So we have to, I will ask these questions now. The annual report will be read. If not we, I am sure you are aware, there are some 3-4 companies which are proxy advisory services today, which are advising the shareholders. They will raise a question. Annual reports are in the public domain. They will raise the questions. They will put a stinker in the market saying that this company, this audit committee, this board of directors have not responded properly to a particular case. It's happened. It's going to happen. In fact, SEBI has issued a circular in November 2013 saying that we are supposed to ask questions on various filings under listing agreements. They say you are expected to ask questions, and we also have to disclose the parameters based on which you are going to ask questions under the various disclosures like shareholding pattern, your financial results, your corporate governance norms and all that, which you have made public already. If you go to the site, you will see what are the parameters on which you are going to ask questions. We have started asking questions. We are asking clarifications. The clarifications sought, clarifications given are already in the public domain. It's already happening already. It's about 2 months, 3 months since we have been putting in the paper. This will go to increase further. RPTs will come hereafter. Corporate governance norms will come hereafter. Independent directors details will come hereafter. Somebody will question independence. We don't know. 3 years there should not be any pecuniary relationship. If the fellow forgets some pecuniary transaction between the two, we don't know where it's going to land up. It's not going to be easy. It's going to be fairly tough regime hereafter.
Who is going to maintain database for independent director?
I have informally, we don't have any concrete information on that. There was one attempt by Institute of Company Secretaries of India to maintain independent directors database. I don't know whether the government is going to permit them or not, or government itself may prepare the database. Prime database already has an independent database, but it does not have a statutory recognition under the provisions of the Act today. So Prime database is a commercial entity. I don't know how far government will allow that to happen. We don't know.
One question. The independent director also will have to satisfy about the risk management.
Yes.
What are the risks? Because as an independent director, is there a business risk which is envisaged or a regulatory risk which is envisaged?
If you read that word risk and threatening the existence, it's not only one risk, it's talking about all the risks. All the risks. The legal risk, reputation risk, business risk, market risk, all risks are concerned.
How as an independent director, because it's difficult. If I think directors,
he has to seek the right questions, he has to ask the right questions to the management and extract information from them. In fact, it says that if required, you have the right to get investigations done. So you do it. As in 3 of independent directors to decide that the company should be investigated or a risk consultant should be appointed to understand the risks of the company and let us know. It has to be done. It has to be done. And you will find independent directors doing all this. All this happen. I have no doubt about that in my mind.
because I think that is too vague. Risk management
is too big a term. Too big a term.
Like currency risk, there are so many risks.
There are so many risks, not one risk. If you are in a business, especially dealing with international businesses, you have multiple risks to deal with. So you have got to have an assessment. It would mean a professionally qualified risk manager has to initiate the risks, make a report to the committee, and committee should say, okay, everything is managed or not managed.
Is it possible that a small committee is appointed as a risk committee, by the audit committee to look after, who are the HODs of the various members?
If I can take the, example from the mutual fund industry, risk management, the capital markets generally risk is perceived as an important thing. and therefore they give two methods of risk management structure in the organizations. One is that you have a chief risk officer or you have a risk management committee. The two possible ways of doing it. So you may ask for a chief risk officer who is going to look after the risks of the company. That's one format. Another format is risk management committee will be there, comprising of executives handling various jobs. In my understanding, risk management committee may be a more viable idea because risks in a particular domain will be understood by the professional in that area. One single person understanding the risks of the whole company may be difficult, and therefore I would say risk management committees, executive committees of risk management will be a reality as we go forward. That's what my risk.
One of the independent director has to be member of the risk committee, or not required?
Like structure of the board.
We get the report as an independent director. If the report is received from the risk committee, that should be suffice.
That should be sufficient. That should be sufficient. That should be sufficient. But since board is responsible, they may say, okay, one of the executive directors should be responsible for risk committee, and they report into the board.
That could be one of the executive directors will be part of risk committee.
That's right. That could be one possible format.
One personal question. The man said to vote. Even this kind of provisions, if somebody approaches you to be an independent, will you be interested?
I will be interested in the area where I understand it. I have not to go to petrochemicals and automobiles. Capital markets, probably I will still go. I understand what it is exactly. I don't think one should be scared. One should be aware. I think when you understand this distinction, we should be aware of responsibilities. We should not be scared of responsibilities. One is scared, it's difficult to manage life. If you are aware of your responsibilities, you can always handle it. What's the big deal?
So you don't think that there are chances that good and experienced people will move away and then drivers and fuels will take over?
Now don't think so.
No, if drivers and all, they cannot come if they have taken salary from the remote the last 3 years probably. But I don't think. But that's why that it says, if you look at the first sentence, board has to satisfy itself that the person has got the required expertise, experience and integrity to be appointed independent director. Board has to consciously exercise its wisdom and say, this gentleman is fit to be the independent director of my company.
Expertise in driving.
Really, in mechanism, our fuel is having maximum integrity. Our office is having fuel only.
There will be definitely, I think your point is well taken, there will be definite change in the type of people becoming independent directors. There is no doubt about that. And people who are being independent directors as ornaments, they may withdraw. People, independent directors who are serious in their job, they will stay. That's for sure. It's what is calling for is actually, if you look at the whole structure, you should be serious with your job and perform honestly. That's what they are asking for, in fact. Nothing else.
Intention is good, sir, but ultimate result is not desirable. Because the way things are managed at, penal consequences level and all, so that is not...
That is actually the big problem. Most of the time when the regulations are made with a good intent. But as regulations become routine, the officer, second, third level officer will start applying them in a mechanical way and they start hounding the people for an unreasonable reason. We have seen it actually in many rules that are made. They become checklist kind of things over a period of 3 or 4 years. So the moment it becomes checklist, then rules the spirit and duty of the purpose. We understand.
The provisions are very good, sir. Without any change, they should be made applicable to our representatives.
Kind of compliance cost we
Yes, sir.
have to incur because of this. It's going to be a huge cost for the corporate sector to go through this and then maintain this. So that is going to be a big...
Yeah, I think the secretarial job is going to be more complicated. I have no doubt about that. The job is going to be very much more complicated and it's going to be very sensitive too.
Maybe here also they should have done 3 layers. That a group of companies follow all this. Maybe because otherwise a small listed company, because of legacy it is listed. But they do not have the kind of machinery which is expected because of this regulation.
I will recall one discussion. I am a part of one committee there. Maybe I made a precise statement like this, what you said just now. What they said is, listed company, investors can buy into the shares and therefore investors are threatened. So all listed companies are same for us, big or small. That's the view regulator is taking.
That's true.
It's true, of course. Yeah. So you're saying something, sir?
Most of the tests prescribed in the various schools are subjective in the sense that they do not have any objective test by which you can judge whether you have done your duty correctly or not. So the difficulty can be always made this way, that whereas according to the director or the deputy director, he might have discharged his obligation correctly. At the same set of facts, the government director or the government will come to
Officer, yeah.
So I think we should represent to the government to say that at least as far as possible there should be more of objective criteria against that. Irrespective of qualitative, because otherwise it becomes impossible. But rather in our profession,
Yes, sir.
we have a duty to report on the company accounts. And when we say that it is subject to certain qualifications, the account shows clear and fair. But then if the qualifications are so vital that you cannot say that it shows clear and fair. So you have to report that it doesn't show clear and fair. Now the question here is, in the same set of qualifications, the government might come to a decision that no, you should have qualified completely. You should have said it doesn't show clear and fair. But according to the auditor, it's not so much that it should have taken to very negative. So our guidance book says that the auditor is the final decider whether, unless it is perverse, but otherwise he is the final judge as to whether he should have qualified
Or not.
negative, and that is doesn't show. Now since that is laid down, because even in the court proceedings also, the judge has still that you should have qualified negatively. So the auditor I think that in certain circumstances, there were precedents also, he has done his duty by qualifying. So here also I think some sort of objectivity can be brought, whereby the responsibility of a serious, sincere auditor, a business director also will be unnecessary.
But do you think, sir, I'm just asking a question, sir, do you think secretarial standards can be of some help in this matter, bringing some kind of objectivity to this? Because secretarial standards have been made statutory under the Act now. So do you think that creation of secretarial standards in this area can be of some help?
Yes, certainly. Because that will at least
In a framework.
minimum expectation of what we are supposed to do. The standard now gives as to what is the duty of the director or the independent director, to what extent he should perform, there is a minimum level at which he should do. So if standards are decided, so technical standards, then that will at least make this difficult to follow.
I think we should work on that. That's the reason I was raising the question whether it can be helpful.
How independent directors have to be compensated?
There's no ceiling as such. They said fees are out. Fees is again as per the semi-government rules. And they can share profits.
They can share profit.
They can share profit. There's no bar subject to the 11%, 1%, all the stuff.
1% of
and then reimbursement of expenditure. They are not eligible for ESOPs. That's the only precondition. Otherwise, they can be remunerated. But usual tendency is to stop with fees. They are not generally allowed to share profits. There will be definitely imbalance between the remuneration and responsibility. I have no doubt about it. In fact, if you look at it, the managing director is heavily compensated and he does the work for the work. Here, the work and accountability is more than the work itself. He does not do the work. Look at the problem of independent director. He is not involved into the job, but his accountability is more than the person who is involved into the job. Risk management is a responsibility of the risk committee, let us say, for example. So they are doing some work. But answerability for lack of risk management is an independent director. He does not even know how much of the risk management is controlled in the actual field, but he has to be accountable to the whole world whether risk management is properly implemented or not. That is the problem. Without sinking hands into the work, he has to take responsibility for the whole thing. He has to go by, he is not coming every day to the office as somebody said, but he has to rely on the statements made before the committee, based on which he has to take the accountability, and he has to stick his neck out. It is a very big responsibility. No doubt about it.
Does he remain independent in that case? Because if something goes wrong, he will try to say risk.
Yes.
Try to hide something.
So it's going to be threatening. It's going to be threatening.
When the redrafting of the constitution was started,
what are the training for the private limited companies, small companies, which you can talk in Indian technical, and now it is very stringent for the large companies. Today, the AMP modifies that whatever functions were available to a private limited company, which are all a subsidiary, because the 56 Act, it is no longer gone, then they have made virtually working by a private limited company. Users now they will provide for contract that this is all private limited company to be involved or involved.
I think we should read the rules carefully. Some of our concerns can be attended. We look because most of the provisions, wherever they said rules, class or classes of companies as prescribed. So probably the class or class of companies, when you read under the rules, you will get some kind of a relief in this. Generally speaking, yeah. No, we have to see. I mean, so far I can't say. I have not read the rules myself, therefore I can't make.
They said the best example of his case is section 185.
Yeah.
The replica of it 295 was exempting private companies.
Yes.
So there was no reason to take away that.
The loss-making private limited company will find it very, very difficult to regulate.
Most of the private companies.
Yeah. It may be by legislative statutory design, they want to create problem, you have to wind up and go. If you can't raise funds, get out.
To subsidies they were exempted.
But as I said, they should fast track to get out at least. To get out at least.
We want to promote entrepreneurship for individuals. Today, even otherwise, very difficult in last 10 years because of so many regulations of regulations of it is the last year in the office.
Not one company, one person company, small company, government company. Every now and then the situation year by year. It's very difficult to make the compliance.
I think cost of running business will increase. There is absolutely no doubt about that. And cost of running business not necessarily because of the productive cost, it's a compliance cost.
I think we had a lot of interesting discussion post your presentation. Thank you very much, sir. May I request now Kaushik to present vote of thanks.
Thank you, Vipul bhai. Friends, I have a great pleasure in proposing a very well-deserved vote of thanks to Dr. V.R. Narasimhan. Dr. V.R. Narasimhan has enlightened and enriched us on a various important aspects like board composition, resignation of director, changing role and responsibility of independent director, issues in related party transaction and whatnot. We are extremely grateful to Dr. V.R. Narasimhan on a working day to spare time and to be with us. On behalf of Chamber of Tax Consultants and on behalf of all of us, I propose a very well-deserved vote of thanks. Please carry with a round. Thank you.
We'll break for about 10 minutes. So next speaker, Nitin Poddar, is expected by about 5:30. So we'll start at about 5:35.
Thank you. Thank you, sir. Thank you.